So his analysis was that essentially Lane Myers, if he gets his injunction against harassment, the civil injunction,
There's only one injunction, and it's the civil one. That's the only one.
appealed and overturned somehow, that is going to have some sort of an effect on the criminal case, the criminal convictions and or the criminal injunction against harassment.
It would have to be on the criminal case because there is no such thing as the criminal injunction against harassment.
And that is the dumbest thing I've ever heard. His justification were just two buzz phrases. He said that if the civil injunction against harassment gets overturned on appeal, that will, I think he said something along the lines of terminate the, or end the criminal conviction by operation of law and or by legal impossibility. And these are buzz phrases that he threw out with zero understanding of either.
Okay, let's hear your understanding of what the first thing that you said was, okay? Let's hear that first, and then we'll see who knows what, all right?
Let's start off.
Y'all ever heard what it sounds like when like a 6-year-old eats too much candy and has too much sugar and gets like a sugar rush and then starts lying about dragons and fucking butterflies and stuff? That's what you're about to hear out of this guy. It's going to be fucking retarded. Get ready.
Is where statutes or contracts can terminate by operation of law. In the contract or in the statute, if they put an end date for that statute to be effective or for the contract to be effective, when you reach that end date, the contract or statute terminates by operation of law. Nobody had to do anything. It didn't have to get repealed. It didn't have to, no, the parties didn't have to meet and renegotiate the contract to terminate it. It just ends by its own terms. It's terminated by operation of law.
Think about what you just heard. Terminated by operation of law. He just explained to us what an expiration date is, like when bananas go bad. But he spent 45 minutes doing it, and he claims this is what Michael Eline can't understand, is an expiration date.
The civil injunction against harassment being
the only one in existence is what he was about to say.
Overturned, which I doubt it will be. It may be remanded for the trial judge to make a decision based on civil harassment.
They're going to remand a civil injunction that was issued by another judge to the trial judge in a criminal case. What the fuck is wrong with you, dude? What the hell?
Law.
Because that's the only law that it can be based on, because there's only one injunction and it's the civil one. So
I think he made it based on criminal harassment law. So it may get remanded to him for that purpose, but I seriously doubt it'll get terminated or set aside.
Vacated.
But it still wouldn't. But you notice, like, in the termination by operation of law, the termination has to be included in the statute or in the contract.
Yeah, okay, whatever. So it's not included in every contract or every civil, criminal, whatever kind of law you're talking about. It's not included that if it is illegal, that it doesn't exist or shouldn't be there. Isn't that in every single legal contract, that if the contract is illegal, that it should be ended? Buddy? And the reason this makes sense to all of us is because we don't suck the government. You know what I mean? This guy cannot picture the government being wrong. So the fact that a legal contract is written illegally and should terminate doesn't click in his head.
The date it's terminated on or the circumstances under which it's terminated. For example,
he's about to go full retard, but this is a really good example of what I'm talking about, and I want to elaborate on his little example here. But this is perfectly perfect what I'm talking about how he can't see certain things because he just doesn't think the government can do any wrong, you know what I mean? And about how other people view certain things. Like, for example, let his example go.
If you pay me $100, I'll make you 100 widgets, right? Once I make you 100 widgets, that contract is now terminated by operation of law.
Okay, yeah, but pay you $100. Now, here's the part that he can't understand. What if that $100 wasn't actual U.S. currency? What if it was something like monopoly money? What if I fooled you with the best monopoly money in the world that looked like U.S. currency, and then you come to find out it's monopoly money? Wouldn't that, by operation of law, terminate the contract because I paid you with illegal money, right? Or what if the widgets worked incorrectly? Is the contract still then terminated, or is it still fulfilled, the parts of the contract? You know what I'm saying? If the contract itself was illegal, or the products or whatever was exchanged was illegal in his little situation, then the contract should terminate because of that, because of the illegality of it. And he can't picture this in his head.
Because the terms have been completed, there's nothing more for it to do. The trial, the civil injunction against harassment.
So illegality. If something is illegal, then it should terminate by operation of law. Now, if the part of the contract that is illegal is the judge's findings making, I don't know, let's say a civil injunction, right? But the judge's findings upon appeal, the appeals court or the appeals judge finds that whatever the judge found was wrong, right? If you remove the judge's findings, that contract now has no basis and can be terminated by the operation of law. So if a appeals court judge doesn't want to call it abuse of discretion, which is what a judge making a bad decision is, and it getting caught on appeal is called abuse of discretion, LeVar versus Cahill. But the thing is the upper court judge, the appeals judge, might not want to, you know what I mean? Again, this is just covering each other's back type shit, but terminating a contract or whatever by operation of law is kind of a way of covering up, or not covering up, but just, making an excuse for a judge that made a bad decision in a lower court. You know what I'm saying? Can be, which is probably what's going to happen here, I'm assuming. But anyways, this guy's a retard.
Is its own separate thing.
No, it's the only thing, because there's only the civil injunction against harassment. Once again, you moron.
Maybe we should get into that for a second. Okay. So you have two different cases.
Absolutely not true. There's one case. And it has a civil injunction against harassment that's attached to it.
The Court of Appeals, if Lane Myers does all the procedural steps required to get the civil injunction against harassment in front of the Court of Appeals would then have jurisdiction to make decisions about that civil injunction against harassment. The criminal trial, the criminal conviction, and the criminal injunction against harassment.
There is no criminal injunction against harassment. There never was, and there's still not one. So, anyway, so you're just talking about the case, okay?
Is a separate thing. The Court of Appeals won't have jurisdiction over this separate thing.
Once you're done with story time, I'm going to explain what a timeline is, right? And so you understand.
So the Court of Appeals can't make any decisions based on this separate thing. That's issue number one. Issue number two is, even though the charges in the criminal case referenced...
Bam! Sorry to yell. But remember that word reference and how he used it. The civil whatever referenced, or the criminal charges referenced a civil injunction. Okay. Think about how de minimis that word is making what it actually is. It's referenced a civil injunction, right? So no big deal, just reference a civil injunction, you know what I'm saying? But no. And then later on, we're going to hear how many times Rachel uses this reference word. The word reference is ridiculous. It's an evil word.
A injunction that was in place.
Okay, keep talking, princess. We're getting there.
It is not up for appeal. So even if the injunction gets set aside, this is its own separate package, and it would have to be separately appealed. An issue there is that...
Okay, so we're going to get his view of this, right? So expiration date, right? So something expires, then it's over with. We understand that, right? But he's saying that the civil injunction is referenced by the criminal, everything that happened in the criminal thing, right? But just because that's true, that the civil thing is separate from the criminal thing, and that the Court of Appeals can't do anything about the criminal thing, they can only do something about the civil thing, right? And that they're completely separate. They are completely separate from each other, is what he is saying, is what he just said, right? Okay. Here's why all that is just absolute garbage.
It is not up for appeal. So even if the injunction gets set aside, this is its own separate package, and it would have to be separately appealed. An issue there is that in the plea deal, Lane Myers agreed that he can't appeal that.
Okay, so here's where he thinks that it's over with, right? Because the civil thing is separate, and it may be referenced in the criminal charges, but it's just a completely separate thing that has nothing to do with it, and that even if it does get set aside, Lane Myers can't appeal the criminal part of it because he agreed not to in his plea agreement or coercion agreement or whatever you want to call it. Okay, all right, here we go.
So that's done. It's never going to get appealed. It's never going to get in front of a court of appeal and be heard on the merits because he agreed. He waived his right to an appeal. He no longer can give that court of appeals jurisdiction to hear an appeal on it because he waived his right to an appeal. He has no right to an appeal. So they're two totally different things. And over in the civil case,
and he just hit that sugar high. I use rainbows, and then the dolphin ate the dragon, and then had a baby, and it was blue and sparkly, and blah blah blah. That's what he's about to say now because he just figured it out, and he has nothing to say, and he's freestyling this live, and this is just funny to watch, man. But anyway, let's just hear him keep going for a little bit, and then I'll do you all a favor and just tell you what it is.
It cannot. There's no mechanism in there to terminate the judgment in the criminal.
Okay, let's go back. He said issue number 1, issue number 2, and then he said a bunch of blah, 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 blah. So let's go back to issue number 1 and issue number 2.
About that civil injunction against harassment. The criminal trial, the criminal conviction, and the criminal injunction against harassment is a separate thing. The Court of Appeals won't have jurisdiction over this separate thing. So the Court of Appeals can't make any decisions based on this separate thing.
Separate thing. Okay.
That's issue number 1. Issue number 2 is even though the charges in the criminal case, referenced a injunction that was in place, nothing in that civil case references the criminal case, and so it cannot. There's no mechanism in there to terminate the judgment in the criminal case.
Okay, like he's saying there's no mechanism to terminate it and blah, blah, blah. Like there has to be some kind of person doing something to terminate this. Like he has to take his criminal trial or his criminal charges to an appeals court or something that he can do. Anyhow, right? What Eli was saying by the termination by operation of law, right? And what Merb is calling the expiration date. Right. Well, we're going to dip into that because this is the first part. And Eli, I think he nailed it on the head with the two buzz terms, as Merb calls them. But so check it out. OK, so here is the definition of the termination of whatever. Oh, it actually sounds cool, too. Termination by operation, motherfucker, right? It refers to the automatic ending of a contract, like you said, if there was an end date or something, or legal relationship due to a specific legal event, rather than the actions of the parties involved, right? So these events can include incapacity, bankruptcy, illegality, right? Like, for example, granting somebody an injunction when all the excuses they gave for the reasons for the injunction were invalid and a bunch of lies, right? Also, if you have like a contestation hearing for your injunction against harassment and you didn't actually hire a lawyer, but you relied on your prosecutor husband to sit behind you during the court function and tell you questions to ask the judge, and then you actually repeat the question that your husband, that's a prosecutor, told you to repeat to the judge, and you did, and then the judge answered it. Something like that. That would be an obvious conflict of interest. On recording with audio and everything. Something like that would work as far as a statutory provision. Now, as far as non-performance or whatever, let's say that you got an injunction against harassment against a person for harassing you when the actual harassment that occurred is people calling you and leaving you messages and voicemails, yet the person that you have the injunction against isn't even accused of any of that. or maybe is, but doesn't take part of it. The impossibility of performance is the fact that there is the contract of an injunction against harassment is that the injunction will prevent harassment. Now, since the actual harassment is people calling and leaving messages, and Lane Myers has no control over other people, the fact that other people are calling and leaving messages will continue regardless of what Lane Myers says or does. See, in that case, the injunction against harassment has an impossibility of performance, because how is it going to stop somebody else from their own free will, their own First Amendment, and their own physical and also financial means to contact this person, right? So just there is no possibility of performance an injunction against harassment against people in other states for harassing someone. The injunction can be vacated or it can be terminated on the impossibility of it stopping the harassment, like it didn't do. You know what I'm saying? The only thing that you're right about is the fact that the law has to terminate this, and the only thing that can't happen is that some action by the parties terminates it. Well, guess what? There is no action by the parties to be had, right? It is only going to be terminated by law, and that's going to happen after Lane Myers fills out a successful appeals brief, and the Court of Appeals looks at it and sees, or just has their pick, just closes their eyes and points to any one of these illegality, impossibility of performance, or statutory provisions, or any two of them, or all three of them. You know what I mean? They're applicable in every single situation because they did such a bad job. Shannon is such a big-ass liar, and Matt Walker is such an unethical piece of shit that them working together leaves them open for any one of these three. And there's numerous different ones for illegality and impossibility of performance and statutory provisions. My bad, I was getting too hyped there. And like you said, as long as there's no action by either one of them, well, the action to appeal it was already taken back in December, you know what I mean? So he's already done that, so that's not an action. Literally, law just needs to take over from here on out after the successful appeals brief is written, you know what I'm saying? And so after that, now, here's the part where you don't, where I can't tell if you're stupid. I mean, you're obviously stupid, but I mean, just these facts, right? I can't tell if you're faking it and you're lying, or if you're stupid to the facts. But after that happens, and the Court of Appeals deems it illegal, right? So now how can the criminal charges possibly exist without this? You claim that they're two separate things, right? When in fact, the agreement that you say binds Lane Myers from appealing it, right, that he agreed not to appeal it or waives his right to appeal it, that document and the charges that he agreed to or whatever, that he signed his name on a dotted line that they said was a confession of guilt or whatever, or plea deal or whatever you want to call it. It is not. That's the same document that is going to set him free, because those charges that he signed to don't exist without this civil injunction being in place. Both of them, right? And that's where they fucked up. They went for the throat, right? But they tried a little bit too hard. If they would have just kept it misdemeanors or whatever, blah, 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 they might have had it. But they wanted to go for the aggravated bullshit, and that's what's going to fucking sink them, because they're greedy pieces of shit. Observe, Merb. All right, try to follow me closely here. Don't lose your marbles over this, okay? But let's pretend that it successfully got to the Court of Appeals. The civil injunction against harassment got to the Court of Appeals. The Court of Appeals looked at it and said, oh my God, Shannon is a shady piece of shit. Matt Walker is a horrible prosecutor and as unethical as it can get. I am going to vacate this bad boy right now, right? So the Court of Appeals vacates the civil injunction against harassment, all right? So that's where we're at. Now, you claim this is where we get stranded, right? Because there's nothing here, like you said, right here.
Nothing in that civil case references the criminal case, and so it cannot. There's no mechanism in there to terminate the judgment in the criminal case.
Not only is there a mechanism in there, you just explained it to us, right? You just explained it to, Eline explained it in your chat, and then you heard about it and called him retarded for it. But he was explaining, here, look, check it out. This is going to explain, too, why the word reference is so stupid. But I agree with you. There is nothing that references it, because it is directly connected to and built on top of it. Okay, here's the criminal case, 2 charges. Let's see if there's nothing that references the civil injunction, or the civil injunction referencing this, or whatever, however you want to look at it. Let's look at, right here. Can you read that, Merb? Can you read what that says? Now, in one of my last videos, I said I was waiting for this moment for some dumbass to call this out or think that they wanted to call this out and say something about it. Thank God it was you. Okay. I just want to be real clear. What he's referring to as a reference is the wording in the actual statute that was used to convict him. In fact, words that were so specific to the statute that if they didn't exist or were not referenced, that the statute would be invalid and not apply to it. So, what do you think a criminal-related injunction means? Right? Tell me what you think that means. Because it's not a criminal injunction, it's criminal related. What's the only thing other than criminal where you can get an injunction for harassment? Civil, you fucking motherfucker. Okay, now let's say I'm wrong, right? Let's say it doesn't mean criminal related as the fact that it's a, criminal injunction against harassment, right? It would mean he would have to be a criminal, but he's not a criminal, and he doesn't have a criminal charge against Shannon Walker. So it's either one or the other. Either one, this charge is invalid as it sits and should just be by rule of whatever the fuck should go away. And two, the word criminal related doesn't mean he's a criminal. It means that the injunction is a civil injunction, right? But he didn't have a criminal injunction against him, so that can't be the case, right? It's either one or the other. It's only one, right? Even if you stretch it, it can't be the other. It's a criminal related injunction, meaning the civil injunction against harassment that he has. Boom, they're tied together. Since that civil injunction has been vacated by the Court of Appeals, guess what? This charge is bogus. You hear Merb where it says injunction against harassment in favor of Shannon Walker to it, injunction against harassment and the order of that the order of the injunction has been served and is valid at the time in violation of blah, 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 right? So the only thing he had served on him and valid at that time was the civil injunction against harassment. So, oh my God, it's referenced. What do you know? Think about this. He had 13 charges, right? Why didn't they, and each one of them are separate, which means each one of them had its own probable cause for an arrest, right? Each one of them is its own crime. That's why they're allowed to charge him like that, right? Okay, so if that's the case, well, the reason that was the case is because they thought that the civil injunction against harassment gave them the probable cause for that, meaning that he knew that he was doing something wrong, and every time he posted a video or did something after that, it was in and of itself its own crime. But now that the civil injunction against harassment, which they were using as the other half of this statute right here that they charged him with, and as the probable cause to even get him there in the first place, is absolutely gone, then so is this charge. Now, if you don't think we can do that with the other one, you're dumb, because we can too. Okay, just to recap for right now, amended count 1, 1454, right? Aggravated harassment, court order in place, a class 6 felony. Without a court order in place or the injunction against harassment being valid, that charge cannot be charged on somebody who doesn't have that civil injunction, right? And now that the civil injunction is gone, this charge is impossible, right? Impossible. So we'll scratch that one off as an impossibility. And so here's what's left. And now here's the final nail in the coffin for your stupid ass theory. Now, look at the first charge. Look at the dates. September 12th, 2024 through February 22nd. September 12th. I wonder let's go back. Well, what day was that? Oh, the very first day in the very first instance where Shannon Walker wrote something down on the petition for the civil injunction against harassment that's been vacated and doesn't exist, you moron. I mean, hypothetically, of course. Hey, Merb, remember a little bit ago whenever you said this about there not being anything referencing anything that's on the thing? Remember you said this?
Nothing in that civil case references the criminal case, and so.
Hey, Merb, you see that right there? It says 912 and then a bunch of words. And then right here on the criminal complaint or the criminal, whatever you want to call it, it says September 12th. You know, that's because they use this exact same document. It is appealable by your words. You said it's not appealable because there's nothing that references it, so there's no correlation or there's no jurisdiction. Well, guess what? There is now, bitch, and I didn't even know that. Thanks for the tip, dude. Both of these criminal charges both reference a civil injunction against harassment that is garbage that's going to get thrown out, and then guess what? These are going to get thrown out too. Hey, Merb, you see that? Those are references to a civil injunction, you moron. What was that second thing Eline said? The impossibility of something, or what was that terminology? Okay. All right, I'm going to slow it down for you, Merb, one more time so you understand, right? Because, I'm trying to help you out, bro.
And that is the dumbest thing I've ever heard. His justification were just two buzz phrases. He said that if the civil injunction against harassment gets overturned on appeal, that will, I I think he said something along the lines of terminate the or end the criminal conviction by operation of law.
No. See here, okay. The operation, once the civil injunction gets terminated, right, which it will, then there's going to be no basis for the charges, right? But like you said, Lane Myers can't appeal it. The operation of law is going to automatically have it reviewed by an appeals court because because it's an impossibility as it sits, right? So the court's going to have to look at it and see what the fuck's up, right? So he's not going to have to appeal it once the civil injunction's gone because it's gonna have to be looked at. It's like if you get convicted of murder, but the murder suspect or victim or whatever suddenly it just appears alive, in the courtroom or whatever. By operation of law, you're going to have to go look at that conviction again, right? You're going to have to look at how it got there and find out what the deal is, right? By operation of law. Then once you find out that it's impossible for somebody to be convicted of murder because the person they're convicted of murdering is standing right there saying, "Hey, I'm alive," you know what I mean? Then you're going to have to terminate that because it's an impossibility, right? You know what I mean? The charge of murder is impossible if the person's alive.
And or by legal impossibility.
Yes, it is legally impossible to murder somebody if they're alive. Or to have been convicted of aggravated harassment charges if you don't have the injunction against harassment at the time of the charges. You know what I mean? That's an impossibility legally. Or that your stalking charges are based upon legal communications and constitutionally protected behavior. How could that be how could you legally convict somebody of that if it was all legal behavior? That would be an impossibility, wouldn't it now, Merbles? Then the current charges that he has signed his name for or whatever or is convicted of is a legal impossibility. Those charges can't exist because the civil injunction was vacated because both of the charges rely on the civil injunction's validness and issuance at the time to exist. Okay, does that make sense? Because one of them is aggravated, and it literally says that he had an injunction against harassment that was valid to make that one valid, and the other one uses the dates from the petition. Does that make sense, Merby? Or do you need me to get my color crayons out and drop little stick figures and stuff?
Good morning. Happy Tuesday. So in my chat yesterday, apparently Eline did a video on Lane Myers, and once again, Eline is fucking retarded.
That's funny that you said that, Merb. The reason I say it's funny is because it was obviously an attempt at comedy because Michael Eline is not retarded. So since you put a comedy section in your video, I'm going to put a comedy section right now in this video. So everything that you hear after this is just comedy, right? Because, of course, roasting somebody else like how you just did. So here's the comedy. Fucking funny that you say that because you're a fucking state-sponsored puppet, dude. Eline has more integrity in his little fucking pinky finger than you and all your paid subscribers do. When you click promotions and, pay $200, $300, $400 to get subscribers and shit, you're a piece of shit, dude. But I can't talk too much shit because you actually gave us and everybody else that's going to see this even more hope because you actually told us now that it actually is 100% possible for this to play out the way the legal genius-minded person Eline said. Now, at least cut that beard off. It doesn't make you look smart, dude. You look like you have a vagina chin, right? It doesn't look like you're going to have a masculine chin. Let the world see your chin. Cut the beard off and show us the vagina hiding behind your beard. Like a weeping vagina. Show the world your weeping vagina. I mean, Jesus, what are you, like 5'3" or 5'4"? You know what I'm saying? You got a big head, like Peter Dinklage, or are you just like misproportioned? Like your face is like of the right size, but like you have a super small midget body. Except Peter Dinklage actually gets laid by medieval strippers, and like when you go to the strip club, you like actually think the strippers like you. You know what I mean? You're that weird one that's in the front like that. I mean, they must look at you and feel so disappointed, like their fathers are disappointed in them. You know what I mean? It's like your face is disappointing. It's like you draw something really nice and you look at it for the last second, and then you accidentally get like your wet palm print on it, and it's just a smudge, like your face is just like a disappointing smudge on the world. Like you're just a smudge, like nothing else, just a disappointing blur. You know, Eli's probably 20 years past giving a shit, but I'm sure there was one point in his life where he would have took your little midget ass and fucking picked you up by one hand and smacked you on the hood of his truck, duct taped you there, drove you to the beach, and started feeding the seagulls Cheetos to watch them shit on you for hours, dude. At least, I mean, that's what I picture would happen. You know what I mean? If you decided to be a little fucking pipsqueak shithead and call people things that they're not. You know what I mean? Oh, yeah, your little sausage fingers. I can see those little sausage fingers. Is that why they call you Merb? Because you got little Merby sausage fingers? You look like you look like your name could be Marybelle or something, but they just shortened it because your little tiny fingers. Do you make that little ID sign with your thumb and forefinger like a cop, you know what I mean, whenever you talk to people? Or when you get home, you just act like Dr. Evil's little accomplice, just running around like sucking on your sausage fingers, you know, doing the same mannerisms as grown-ups and shit. Stupid ass. Is that like a 0.3 lens, or can you even reach the steering wheel? It doesn't look like you'd be able to. It looks like you'd have a lot of trouble, like a Tyrannosaurus Rex, like trying to pick an orange out of an orange tree, or like an alligator, like trying to like deal cards or something, man. You look like you have really, really short forearms, dude, and probably like have like some kind of like classic tattoo on there, like a little naked girl or something. Wow, and I never noticed the haircut, man, like the way it's parted like that. Is that because you run really fast in a sideways direction, or is it because you leave the window down and just let your head kind of hang out like a dog and drool all over yourself while you're driving really fast? Is that why it's like that, or do you do that on purpose, or what's going on with that? Is that hair gel, or is that just jizz from like 4 days ago that you just like the way it smells now? Are your eyes really that close together? I mean, that's like a sign of Down syndrome, man. I can see it, though, because, I mean, you do have Down syndrome like characteristics, you know what I mean? Do you still get jealous of normal-sized people and then go buy, like, a pair of big and tall pants and then sit on a really tall barber stool and then let the pants hang down low so it looks like your shins are, like, twice as long as they normally are, like a normal person, and then just set shoes at the bottom of it and pretend like you're standing up and walking like a normal person? Do you still do that? Or did you just do that when you were a kid? And that ends the comedy portion of this. Thank you, everybody. Thank you. I know. Enough with the clapping. Shut up.